The theme of these seminars, to remind you all, was that you should all look to be modern employers. And many years ago, when we started on this journey, it was perhaps the antithesis of what we were seeing happening in employment law. Over the years, and increasingly with what's coming, it seems as if you have no choice but to be a modern employer. But what we're going to do today is try and give you some very practical advice, hopefully give you some ideas, some tools to take away to help you deal with the change that is coming. And let me assure you, change is coming. What we are going to touch upon today is some of the legal changes that have already happened, flexible working, holiday. We're going to be talking about new laws in regards to harassment. I'm going to be taking you through some of my predictions as to what I think may happen in the coming months ahead. There's a fairly significant political event on the horizon, and you won't be surprised to hear that I'll be touching upon that and what that might mean to all of you as employers. So I'm Dan Chapman, head of the employment team at Leeds Fire. For those that do not know me, most of you do, and it's great to see you all. I'm going to hand you over to our first speaker. I will be back, I'm afraid to say. But without further ado, let's talk about why change is coming.
We have to do a bit of a mic thing now. Because, funnily enough, I don't want to stand here like this. Lovely. Thank you.
Is that okay?
Yeah, perfect. Right, can everybody hear me? Excellent. A good start. Okay. Well, welcome everybody. It's great to see so many familiar faces and lots of new faces as well. So by way of introduction, for those of you who don't know me, I'm Harriet Howes. I'm a senior associate in the employment team. I am a big fan of standing up here and talking to you all about employment law, which makes me a massive nerd, but do bear with me because I like a little bit of audience participation. I like to jazz things up a little bit. We don't just talk about law. It's not a boring session. It's a very sort of proactive, practical session to look at employment law changes. And I've got a pretty unenviable task this morning of covering, I think it's about 13 different changes to legislation that I'm going to be covering, and I've got about 20 to 25 minutes to do it in. So, wish me luck. The first few changes that I'm going to be talking about this morning, I'm just going to be really doing a sort of whistle-stop tour for you, because I'm thinking that most people in the room will be aware of the things that are on this slide in terms of the changes, and then we're going to focus on a couple of changes in a bit more detail and look at practically how they might impact your businesses. So you'll see up on the slide here some of the changes that have come into force this month, or that are due to come into force in the coming months. Starting with the most obvious, the national minimum wage and the national living wage. I'm hoping that everyone here knows that that's gone up this month. Thankfully, and you'll be pleased to hear, I'm not going to stand here and talk you through what the changes are in relation to pounds and pence, because you've got a very jazzy fact sheet in your packs that we have pre-prepared that you can take away with you that sets out all of the different changes to the national living wage, the increases and the national living wage. The only thing that I just wanted to mention on that is that you'll see from the slide that there has been a bit of a change in terms of the categories for the national living wage. So the national living wage is the higher rate. You remember when it was first introduced, it was to cover 25 and over. It then dropped down to cover 23 and over, and as of this year, the national living wage will apply to all workers aged 21 years and older. We are told, because employment laws just get all the lowdown, we are told that as of next year, so April 2025, the national living wage will apply to all workers over 18. So that's what the Low Pay Commission are suggesting is going to happen next year. So I just wanted to flag that for you in terms of sort of forward planning. So that's what I'm going to say about the national living wage and the national minimum wage. There's also the changes in relation to statutory payments, so SSP, SMP, paternity pay and all of those things. Again, all set out in handout. Some of the changes this month also incorporate what we refer to as family-friendly rights. So there's changes in relation to maternity leave, changes in relation to paternity leave, and a new right, a right to take carers leave. So I'm just going to touch on those as well, starting with carers leave. Does everyone in the room know that there's a new right around what carers can take essentially? Leave? Anyone? Everyone know about that? Excellent, okay. So this is a brand new right for employees. It's a day one right, and essentially it is for all employees who have a dependent with a long-term caring need. It's a right to take unpaid time off work, and it's very, very similar to the right to take emergency time off for dependents. I'm not going to go through it in a huge amount of detail, but I am going to do a bit of a shameless sales plug to say that if you do need any help in drafting a carers leave policy, or indeed in terms of any advice around carers leave, do let us know and have a chat to us at the end of the session, and we'll be able to help you with that. The other family-friendly leave, the other family-friendly rights I wanted to just touch upon were in relation to maternity leave and paternity leave. So starting with maternity leave, for those of you who are sort of knowledgeable in terms of HR, you'll know that employees on maternity leave have enhanced protection in a redundancy situation. Okay, this is one of the only examples in UK employment law of positive discrimination. So when an employee is on maternity leave, if they are at risk of redundancy, then they get preferential treatment in terms of any suitable alternative employment. They essentially get first dibs on those jobs. At the moment, that protection only applies whilst they're on maternity leave, but as of April, so as of this month, that period of protection has become much, much wider, and it means that they are protected and they get that enhanced protection from the moment they notify you of their pregnancy all the way through until 18 months after the child is born. So really enhancing that period of protection. So that is one to just bear in mind if you are going through a redundancy or a restructure and you do have anybody on maternity leave. And then the third and final thing that I just wanted to cover in terms of family-friendly rights is changes to paternity leave. Hopefully you'll all be aware, and this will be on your radar, pre-April, paternity leave could only be taken as 1 week or as a 2-week block. As of April, it can now be taken as 2 separate 1-week blocks, so quite a significant change there. The second change for paternity leave is around when an employee can take the leave. Pre-April, the employee had to take the leave within 8 weeks of birth. Post-April, employees can take paternity leave for up to a year after birth. And there's also some quite significant changes in terms of the notice requirements that employees have to give when they want to take paternity leave. So it may be that this hasn't come onto your radar, and if it has, you haven't had an opportunity to update your policies, but it is something that you will need to layer into your policies moving forwards. And again, another shameless plug, we can help you with that, surprise, surprise. So I'm not going to cover neonatal leave because it's not coming until next year, but that's the sort of whistle-stop tour through the April changes to family-friendly rights. The only other 2 things that I just wanted to cover very briefly are tips and TUPE. I'm really glad that I said that correctly. Tips and TUPE, the final stop on the tour of the whistle-stop tour of employment law, before we go on to talk about a couple of things in a bit more detail. In relation to tips, is there anybody in the room who this is likely to be relevant for? Okay, excellent, a few. I'm not going to cover it in detail, but what I am going to do is let you know that we have provided a briefing note. We've prepared a briefing note that covers the changes to tips. It's all around allocation of tips, and if you just, in your packs, you'll see there's a feedback form, and there's a little box that you can tick that says, I would like a briefing note on tips. And if you tick that box, we will send you out some further information on tips. And then the only other thing that I wanted to cover is in relation to TUPE. For those of you who are familiar with TUPE, it's essentially a set of laws that protect employees when the identity of their employer changes, essentially. There's informing and consulting obligations, And the changes that were introduced or that are due to come into force on the 1st of July in relation to TUPE, those changes are around when you have to elect representatives. Again, I'm not going to go into a huge amount of detail, but if you do need any more information, please do let us know and we can give you a bit more of a steer on that. So, that is the whistle-stop tour. I'm now going to focus on two specific changes that I think we've taken the view that for you guys, these are the ones that are going to really make a difference and really going to impact how you manage your staff. So the TUPE changes were fairly pro-employer, so one of the only changes that were pro-employer. The two that I'm going to look at are what we would call pro-employee changes, and they are around flexible working and the new right to request a predictable working pattern. So I'm going to start with the easy one, flexible working. So, without being too philosophical, I think the context of looking at flexible working changes is really key here, because since the pandemic, there really has been a massive shift in how people work, what employees' expectations are in terms of flexible working, all of these things on the slide here, hybrid working, core hours, job sharing, compressed hours. You know, 5 years ago, people weren't talking about these sorts of things in terms of expectations that they might have in the workplace. There's been a real shift, and I think it's fair to say that for lots of businesses, that shift for employees isn't necessarily mirrored in the way that you as employers might want to manage your workforce. I think that's fair to say. I'm trying to be quite neutral here. So there is a bit of a disconnect. And some of you might have seen a few months ago, earlier on in the year, Alan Sugar made some fairly damning remarks about working from home and how awful it was, and it was bad for morale, and nobody can learn anything in their pyjamas. And actually, when I was preparing for this session at home in my pyjamas, I thought, no, you're wrong, Mr. Sugar. But, you know, I don't think the disconnect is quite as stark as Mr. Sugar would have us believe. But I do think that when you're thinking about flexible working in your workplace and when you're thinking about the changes that are coming in or that have come in, it's worth looking at all of these things and working out what you as a business, how you want how you want these societal changes to affect your business. Do you want to be flexible? Can you be flexible? All of those things are really important considerations. So we're going to look at the changes to flexible working that have come into force this month. Firstly, just to clarify, I'm hoping that nobody in the room has seen this misreporting and believed it. The changes do not mean that there is now a right to work flexibly. It is still just a right to request to work flexibly, or as actually I heard it referred to recently that I really liked, a right to ask nicely. So that it's just a right to ask nicely to work flexibly. There are some significant changes though. If you haven't updated your policies, then now is the time to do so. The changes are around formal requests. There is no longer a need, and this is probably the key one, for you to have 26 weeks service as an employee to make the request. It's a day one right, okay? Employees can now make 2 requests in a 12-month period rather than just 1. There's now only a 2-month time frame within which you have to deal with the request, and you can't refuse the request unless you have properly consulted with the employee. So what does that mean for you? More requests, more employees who can make the requests, and less time to deal with them. And as if that wasn't enough, alongside those changes to flexible working is the brand new right that's coming in, we're told, in September, in relation to the right to request or the right to ask nicely for a predictable working pattern. So this comes from, some of you might remember the Taylor report and the Good Work Plan. It was introduced in April 2020. We were kind of busy with other things in April 2020 because something like a pandemic was going on at the same time. So all of this was a bit lost, but the government had said back then, we're going to do a lot more to protect employees, zero hours workers essentially. And 4.5 years later, this legislation is coming into force. The right to request a predictable working pattern is going to apply to employees, workers and agency workers where there is a lack of predictability in their working patterns. What that means will not be defined in the law, of course, because that would make it too easy. It's going to apply, we think, to everybody who's got more than 26 weeks service, or certainly for employees. It's going to be similarly to the flexible working regime, up to 2 requests in any 12 months. You're only going to have a month to deal with it, with any requests, and it's the framework itself and the process is going to be similar to the flexible working process. So it's going to cover things like, if you've got 0-hour staff, they will have the right to request to work set days, set hours, set times. If you've got employees who are fixed-term employees, so they're only employed for 3 months, 6 months, a year, they will have the right to request a longer term, or in fact the right to say, look, I just want to be employed on a permanent basis. And really importantly, for anybody in the room who hires agency workers, have we got anyone who uses agency staff here? Yeah, a few. Agency workers will have the right to come to you as the hirer to ask you for a direct contract of employment, so to circumvent their agency essentially. So I'm not going to go over in any more detail than that this new right, because as I say, it's not coming into force until September. The legislation as drafted is littered with errors, so I'm not entirely sure I'd be able to explain it to you even if I wanted to. But to just cover that off in a nutshell, again it means even more requests from even more staff with even less time to do it in. So I think in terms of how you might want to practically think about how your business will be dealing with these situations, process is going to be really key, as it always is with employment law. So I've just set out here on the slide some things to think about when you're dealing with both flexible working requests and requests to a predictable working pattern. Key is going to be making sure that you gather all of the information that you can. One of the things that we're going to come on to talk about is looking at dealing with informal requests versus formal requests, because remember that all of these rules only cover formal requests. But you do want to have a think about how you're going to deal with informal requests. You're going to need to consult with your employees to talk through their requests in a bit more detail. You're going to make sure that you need to properly communicate the outcome to whether or not you're going to agree the request, whether or not you're going to come up with a compromise, whether or not you're just going to flat out refuse, or whether or not you might want to think about a trial period. So all of these things are going to be really important in terms of process. And you've also got the obligation under the statutory framework, so with a formal request, to deal with any appeals. So it does mean that as employers and HR professionals, you've got more to deal with in terms of process. But I'm going to come on shortly to just look at some of the sort of more practical things that you can do to get ahead of this, to get ahead of the curve. But before I do that, it wouldn't be an employment law seminar without a scary slide on what happens if you get it all wrong. Because obviously we do like to scare you, no, don't we? But as I say, we do need to just cover off why it's important to follow these processes, because it can land you in hot water if you don't. So here it is, the scary slide. If you don't follow the statutory framework that covers flexible working and the upcoming framework that will cover the right to request a predictable working pattern, that's a standalone claim for an employee to bring. The other claims that they can bring are claims around detriment and unfair dismissal. So if they try and argue that they're being treated less favourably for requesting flexible work, or they try and argue that you fired them because they requested a predictable working pattern, those are the types of claims that you need to be careful of as well. And then the biggie that links to both of these types of rights is discrimination claims. The vast majority of claims in relation to flexible working are around childcare and the childcare disparity between men and women. So tacked alongside that is almost always a claim for indirect discrimination. So there's a lot of claims that employees can bring if you get this wrong. And you've also then got the legal costs. You know, as much as we're more than happy to help you with employment tribunal claims, it doesn't come for free, unfortunately. It's bad for PR, it's bad for morale, it's bad for productivity. I think I've probably done enough to scare you all into making sure that you've updated your policies and that you come and get advice from us. So I'm going to move swiftly on to the key points for you guys in terms of getting ahead of the curve. What can you do, bearing in mind these changes that are coming into force, to really make them work for your business, to embrace the changes, to be modern employers about it? What can you do? So looking firstly, and you'll see on the slide, there's a big exclamation mark in the corner that says policies. We love to draft a policy in the Leeds Prior Employment team. So flexible working policies and policies in relation to the new right to request a predictable working pattern are going to be absolutely key. So I did mention at the beginning, for those of you who don't know me, I do like a bit of audience participation. So I'm going to ask you to be very, very honest. What's said in this room stays in this room. Hands up if you've got a written flexible working policy. It should be most of you. Okay, most of you. Right. Keep your hand up if you've amended your flexible working policy this month. Oh, I'm very impressed. I'm very impressed. Well done, well done. But that means there's a fair few in the room who haven't updated their flexible working policies yet. But don't worry about that, because that's what we're here for. We can absolutely help with updating your flexible working policies. But one thing that we would say before you do that, and if you've already updated your flexible working policy, this isn't necessarily an issue. But we're working with lots of businesses to look on a more strategic level at how you might want to deal with flexible working applications within your business specifically. So you can have a standard flexible working policy that says you'll call a meeting, you'll send a letter, you'll have an appeal hearing. But actually, before you do all of that, is it worth spending some time thinking about how your business wants to deal with flexible working? So thinking and looking at some of these considerations on a sort of high level, what does your business do? What does it need from its staff? What do your staff arrangements and staff contracts currently say? So if your business needs flexibility and needs that sort of varying different staff doing varying different things and varying different hours, then work out what you need, look at it on a big scale, and work out whether or not there's anything that you need to do now before the right to request a predictable working pattern comes into force, and while you're looking at flexible working, can you make changes now to make this more effective for your business? Lots of employers will find that they've got contracts of employment for their staff that don't necessarily reflect what your staff actually do on the ground and what your business needs them to do. So it's really worth having a look at what you've got in place now. Is it fit for purpose? And if it isn't, making those changes. And also, if you're using flexible staff at the moment, you've got 0 hours employees, and actually they don't need to be on 0 hours contracts, then change them. Because if you change them and put them on permanent contracts, then they're not going to be able to make requests for a predictable working pattern, because you'll have already given them a predictable working pattern. So it's really worth spending the time just thinking about what your business needs. And also just in terms of sort of following that through, when you're looking at your policies and when you're looking at updating and changing your policies, thinking about how on the ground you want to be dealing with these requests, because there is a statutory framework that says you've got to have meetings and you've got to send letters and you've got to do an appeal, but you can also layer into that an informal process, preempt that. Have a process whereby employees can make requests informally. It means that you don't have to worry about the statutory framework necessarily applying, because you can deal with it all informally, just as you would in your grievance policies, in your disciplinary policies, in your sickness absence policies. Each of those policies will more than likely have a stage where you deal with things informally. absolutely advise that you have exactly the same flexible working policy, because it will allow you to just be a bit more, have these things a bit more fit for purpose for your own business. And then some of the other things to think about in terms of how your policies might look. Do you want to think about when, not only having informal requests and then formal requests, but setting out in your flexible working policy what your sort of core business hours and core business needs are. Because again, you can refer back to that when you're dealing with these requests. So one of the things that we've got on there is thinking about having core business hours, so that actually if you've got somebody who makes a flexible working request and they want to work outside the core business hours, it's much easier for you to point to the core business hours. One thing I would say with that is that that's a bit of a double-edged sword, because then if you get somebody making a request for compressed hours to work only within your core hours, it might be more difficult to reject that request. But I just wanted to wrap up by just saying all of these things, all of these sort of strategic considerations are all things that you need to be thinking about before you start changing the policies, because actually it will then mean that your jobs are a bit easier when you have to implement the policies. So I'm going to hand over now to Sarah to deal with holiday. So good luck.
Is the man coming? Well, I made it upstairs, so that's fine. Yeah, through the short straw on this one, didn't I? Holiday pay. Anyone know it? Anyone know the new law? And damn it, that was my out. Okay, so you may well know, sorry, I haven't introduced myself. Those of you who don't know me, my name is Sarah Appleton. I am a partner in the employment team. I love doing this stuff because I'm a nerd. Apparently I also love holiday pay. So, you will all remember, you've probably been to millions and millions of employment law seminars dealing with holiday pay. You've been to loads of cases that say what is and isn't included. You will also remember probably the last time we stood up, Dan putting his head in his hands about a very big holiday pay case, which essentially said that someone could work 1 week a year, be paid £1,000 for that week, and then be entitled to £5,600 in holiday pay, which obviously was not great. It was also generally complicated. But, hurrah, we have new law which fixes all of that, simplifies it, and I think you will agree after the next sort of 15-20 minutes that it's really easy, really simple, you all know what you're doing. So, first thing to remember is the entitlement to holiday and the entitlement to pay are different things. They are provided for in slightly different laws. So the fact that you're giving someone all of their holiday entitlement might mean that you're not paying them correctly. And again, the fact that you are paying them their holiday pay might not mean that you are complying with your obligation to give them their leave. They are totally different things. Most people conflate them. It's absolutely fine, but now you know you can be all smart and snarky when an employee comes and talks to you about it. So, the new law. This applies to holiday years starting after the 1st of April 2024. So if your holiday year runs to your calendar year, you've got 8 months to plot how you're going to make these changes work to your advantage, if you can. And whilst this is called Modern Employer, this bit, not modern. This is very much, let's spin it to make it work for you. Okay, so, who does this new law apply to? So it applies to everyone, but it expressly changes the position for part-year workers, as it says there, and irregular hours workers. So a part-year worker is someone who the law very helpfully defines as under the terms of their contract is required to work for only part of the year, and there are periods of at least a week when they don't work and they don't get paid. So probably that's going to be teachers, term time only staff. If you're sneaky, you could change the way you contract with your staff to make many, many more of them part-year workers, because technically all you'll need to do is designate a week in their contract where they don't work and they don't get paid. You can leave their pay the same for your purposes, and they fall into the definition of a part-year worker, and that means all the things that we're going to go through will apply to those people. The other people this applies to, as it says there, is a regular hours workers, so again, under the terms of their contract. They've got their paid hours per pay period are wholly or mostly variable. So 0 hours, casual workers, or people on genuinely variable shifts. This that we're going to go through applies to those people. So leave entitlement, so the amount of time entitled to take off. 12.07% of hours worked in a pay period, calculated on the last day of the pay period. I told you this was really easy and simple. So a pay period is when people get paid. So if they're paid weekly, a week is their pay period. If they're paid monthly, a month is their pay period. And at the end of every week or every month, there's a lot of work to be done here, you calculate their 12.07 of their hours worked, and that is their entitlement in hours to take holiday. That is then capped at 28 days in a year. Days, not defined. But theoretically, you could make that work for you. So if you have someone who works 9-hour days habitually, they would be entitled, I've done some maths and it did take me a while, Dan helped me, to 31.38 days of holiday in a year, but law has capped it 28. So you as an employer win. Makes sense? You're with me. I've got lots of people looking at me like, this is hard. I told you it was hard. So that's even entitlement. Pay. Even simpler. So there are 2 ways you can now pay those categories of staff that we've just referred to. So term time or irregular hours. So you can pay it as part of their usual pay in what's called rolled up holiday pay. Does anyone remember that? Yeah? That became unlawful when I was in my mid-20s, yes Alex, in 2006. It's now back officially. Now lots and lots of businesses just kept going with it and it's largely been okay. If you've been doing it, you've been breaking the law, but it's fine, you can now do it again. So that is 12.07% of total pay, and that will be absolutely everything in that pay period. And you just add it on top of their hourly rates. They're paid their holidays on top of their hourly rate as they go along. You have to show it on their pay slip. So you need to say your basic hours are blah and your holiday pay is blah to show that you've paid it. When they then go off, they don't get any pay at all. So their pay will then fluctuate throughout the year. You still, when you're rolling up holiday pay, have to ensure they're taking their leave entitlement. They have a legal entitlement under the working time regulations to 28 days off per year. So they have to take that as well. You've got to make sure you do both. So that's rolling up holiday pay. The other way to do it is, sort of as you usually would, is when employees take holidays as they go. So when your employees go off, you take their average hourly rate of pay over the last 52 weeks that they worked, excluding any weeks that they're off sick or that they're on maternity, paternity, shared parental leave. Average it all out, and then you pay them that when they take their holiday. Told you this was easy. So pay includes payments intrinsically linked to the performance of tasks. So commission, shift allowances, any premiums, that all forms part of pay that you have to factor in. Length of service payments, qualification payments, skills payments, anything that you're getting an uplift because you're a supervisor, for instance, that all falls in. And then, helpfully, overtime and other payments regularly paid, not defined, over the last 52 weeks. So, overtime once or twice in a year, is that regular? Probably not. Overtime every month, probably regular enough. I told you it's so clear, it's so simple, really easy. It's specifically not expenses, benefits in kind, or genuine one-off discretionary payments. Those fall outside of pay, but all of those other things that I've covered fall inside of pay. If you average it all up, counting back your 52 weeks, and then you pay them that when they take their holiday. Okay. So that's really simple for all of those things. So what's the position for everybody else? So these are our staff who aren't irregular hours workers and aren't part-year workers. You can't roll up their holiday pay legally, so no roll up for them. There's no 28-day cap on their entitlement to take holiday, but of course your contracts will say anyway how much holiday they're entitled to. Make sure you give them that, pretty please. Full-time employees, as a reminder, entitled to 28 days or 5.6 weeks of leave. For people with normal hours but variable pay, so people who work shifts, for instance, they might work day shifts and night shifts, so their pay will fluctuate. You average out their holiday, when you pay them their holiday, you average out over 52 weeks that they worked previously. That hasn't changed really, it's just now written down a bit more clearly. For people with normal working hours whose pay doesn't vary, so anyone who's on a set salary and they get paid the same every single month, so probably for most people in this room, most of your full-time staff. It is now codified in law. Now this was all in case law before, but I doubt any of you are doing it, that for the first 4 weeks or 20 days, they're entitled to holiday pay based on their average pay over the last 52 weeks. And for the remaining 1.6 weeks, or 8 days, you can pay them their holiday pay on their basic pay only. Everyone's been doing that, right? Thought so. It's been like that for years. No one has been doing it. It is now written down in law that you should be. But before we come on to that, what counts as pay? So all of those things that we've just covered, what about bonuses? So, bonus is included where it's an incentive payment, so if it's an efficiency bonus or productivity bonus, if any of you give those are in. Bonuses based on personal performance form part of pay. They have to be calculated when you pay someone on holiday, and attendance bonuses, they are all in, they count as pay, they're factored into holiday pay. What is out? Genuinely one-off payments, as before, and bonuses purely based on company profit. Don't count, you don't have to factor those in when you pay holiday pay. What we don't know, because helpfully the law hasn't said, and the Court of Appeal, when asked to comment on this, as to whether bankers' bonuses formed part of holiday pay, for reasons I couldn't possibly guess at, declined to comment, would not say what their view was on that. So an annual discretionary bonus, we don't know. Our view, for what it's worth, is we would rely on this bit of the law that says it has to be paid regularly over the past 52 weeks. An annual bonus, we are saying, we might be proved wrong, but this is our view at the moment, an annual bonus is not regular. That's the argument we're all going to run, okay? Loyalty bonuses, same sort of thing. If they're paid annually, probably not. If they're paid every 6 months, arguable. If they're paid quarterly, almost certainly they fall in. But unhelpfully, we don't actually have any law on that. Okay. So these are things that you all need to think about, having now learned the law of holiday pay. So, can you be sneaky? Can you change the way you contract with your staff now, particularly if your holiday year runs from January? You've got time to do this, to make this work to your advantage. Can you bring them in scope to be a regular hours worker or a part-year worker so that you can roll up their holiday pay? Is that going to work for your business? It might not. It requires some quite clever maths. I mean, I can't help you with that. I'm not so good at maths. Call down if you want the maths. But theoretically, you could make it work to your advantage. Equally, if you change the way you allocate hours, again, you could make that work to your advantage. If you can spin the way where hours are taken and then set holiday periods to fall in with that, you could have an impact on your cash flow, or you could artificially bend how much holiday pay people are getting. Again, it is very, very complicated, require a lot of coffee and an Excel spreadsheet, I'm guessing. Do you need to tweak your bonus schemes? If you're paying a quarterly bonus scheme, that needs to be factored into your holiday pay. I would, as your mean employer-focused lawyer, advise you to change that scheme. Stop paying it quarterly, stop paying it 6 monthly, and pay it yearly, if your cash flow will allow you to do that, because that means it falls out of the holiday pay rules. How are you going to pay your full-time staff? Are you going to keep doing what you're doing? Which probably is wrong, sorry. It doesn't matter if you are, we'll stand behind you. And most employees, most full-time employees in particular, won't bill over this. They won't know that they're entitled to probably more than you're paying them. So you could just stick to what you're doing, run the risk that, yeah, if they ever work it out, Martin Lewis has an annoying article about it. You might, he's a thorn in my side, that man. He's also almost always wrong. But when he does this annoying article, they might all pipe up, but you could keep going and accept that if they pipe up, you might have some back payments and some uncomfortable conversations. You could change it. You could change it to that 52-week average. You could change that for all of the holidays, so all of that 5.6 weeks. Or you could do it for 4 weeks and then pay the other 1.6 weeks at basic pay. Not sure your payroll people will thank you if you decide to do it that way, but the directors might, because you might save them some money. If you're going to change it, how are you going to spin it? So if you are sitting here thinking, oh, we've been doing that wrong, we've underpaid holiday for ages, are you going to start doing it correctly? But again, I told you I am fundamentally quite mean. Spin this as a great benefit. Great news, guys, we've changed the way we're paying holiday. You're going to get more. Happy days. You're complying with the law, but you're selling to your staff that you are wonderful and lovely and modern. I got that word in at least. In any case, oh, last thing, just to throw one of this back in work, as Harriet has explained, there is a right to request a predictable working pattern, probably, come September. So you could do all of that, get all of your staff on variable hours contracts to make it work to your holiday pay laws. When they all request to work predictably, if you accept that, this is all unravelled and you have to go back to what you did before. I told you it was simple. In any case, genuinely, think about, for any regular hours or term time staff, part-year staff, sorry, that you've got, think about how you are calculating their holiday, because you probably do need to update their contracts in any event, because the law has definitely changed for them. If you want to change it with anyone else, then think about it, get ahead, do some maths, and make it work for you. Right, holiday pay experts now, aren't you? Easy. So let's move on. Something loads more fun, harassment. AKA banter. So, harassment, as it says there, unwanted conduct related to a protected characteristic which has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for that person. This is banter, basically. It's not just banter at work either. It's banter on the WhatsApp, it's banter in the pub, it's banter at the Christmas party, it's getting handsy at the Christmas party. All of this counts. All of this counts. This is the current law. So it applies to all of our protected characteristics. I'm not going to make you shout them out, don't worry, but I did have to write them down because it turns out remembering 9 words this early in the morning, quite difficult. So they are age, sex, disability, race, marriage or civil partnership, pregnancy or maternity status, gender assignment status, religion or belief, or sexual orientation. So if you say or do something to someone who holds one of those characteristics, which essentially upsets them or offends them, you may have harassed them, or one of your employees may have harassed them. Now currently, which feels a little bit bizarre, there's no positive duty to take steps to prevent that. As employers, you don't actively have to say to people, you shouldn't be doing those things. But the reason we would suggest that certainly you should have been doing, and you should be doing in the future, is that little bubble at the bottom, the reasonable steps defence, also known as the more on defence. If you are sued for harassment on one of your staff, if you can show that you did everything you could on the ground to try and eradicate harassment in the workplace, you can say, look, we did everything we could. We had a policy, we gave them training, we disciplined people who were harassing people, we were monitoring it. If you can show all of that, and you're sued for harassment, you can say, well, it's not our fault, because we did all we could, but that errant employee over there just went on a frolic of his own, and he's just a bad egg. And legally, that helps us minimise your compensation or reduce your compensation to nothing in the event that you get sued in an employment tribunal. That's the current position. So, from October 2024, probably, the law is changing. Now, there's a number of reasons why this is changing. It's changing in relation to sexual harassment only. The TUC says that 60% of women have experienced sexual harassment at work. That is 3 in 5 women. So those 2 front rows, that first row, all of you have experienced sexual harassment at work on those averages. That's high, isn't it? 50% of those, so 1.5 of you, have experienced that more than 6 times. That's not hugely shocking, probably, to the employment lawyers in the room. It's probably quite shocking for everyone else in the room. 75% of that is not reported. So no one knows about it, no one deals about it, they're just being harassed in silence, essentially. And the law has quite rightly said, not okay, not having that, we're going to change it. So there is now, and there will be, an additional positive duty to take reasonable steps, it says there, to protect your employees from sexual harassment. Now, the stats I've used, and what will probably have come to most people's minds, is sexual harassment from a man to a woman. This covers anything else, so it's from a woman to a man to a man, a woman to a woman, a non-binary person to a non-binary person. Any form of harassment, any direction, based on someone's sex, is going to be caught by this. So whilst any businesses in the room sat there thinking, well, my workforce is 90% male, I don't need to worry about this, you really do. It applies to everybody. It doesn't, interestingly, apply to harassment from third parties. So when this was first tabled, there was going to be a duty for employers to protect their employees from harassment from clients, suppliers, customers, people they come into contact with. There's been a very deliberate backpedal from that. That has not come into force. So there's no duty on employers to do that. I would suggest it is a good idea that you do, but legally you don't have to. And if you don't, and you're found guilty of harassment, there's a 25% uplift on compensation. And that is presumed. It's automatically added on, and then Dan has to fight to battle it down in court for you, essentially. So what is sexual harassment? Because it's one of those things everyone sort of bandies around. Is it telling a colleague that they look hot? Do you reckon? Yeah. Is it talking about the sexual escapades that you had at the weekend at work? Yep. Is it discussing in the office your foot fetish? Mentioning no names. Do we think that might be sexual harassment? Probably, if someone's offended by it. Is it misreading the signals at a Christmas party and trying it on? Could be, yeah, probably. All of those things count. And it sounds really obvious, but it's one of those things, unless you go through it, it's so easy for people to think, oh, well, that's okay. And it's just, this duty is reminding people what is and is not okay. So, what are those reasonable steps? So, risk assessments. You've got to risk assess how likely it is that sexual harassment is going to occur in your workplace or at work functions or in the WhatsApp chats. Honestly, I've not yet turned my mind to working out what a risk assessment would look like. There is a statutory code of practice coming on all of this, which is sort of guidelines that go along with the law. I would imagine that will have some suggestions for what should be in a risk assessment. If not, it's on mine and Harriet's list to write the risk assessment. Don't ask for it in the next week, because we haven't written it, but we will have done. Reporting procedures. Again, seems like a really obvious point, but we would probably say referring someone to the grievance policy in that situation is highly unlikely to be enough. The reason being, a grievance might be, oh, so-and-so didn't talk to me when I came in the other day, or so-and-so leaves their cheese in the fridge and it really irritates me because it smells. That's grievance procedure stuff. Someone coming and saying, I have been sexually harassed by that woman over there, is clearly another level, and it needs to be handled very differently and much more sensitively for all parties involved, both the accused and the one doing the accusing. So we would say you probably need slightly beefier reporting procedures, slightly more sensitive reporting procedures to make sure you're ticking all of your duties there. The guidance currently says sexual harassment champions. I'm not really on board with that term for obvious reasons. We are as yet to come up with a better phrase. So if anyone's got an idea, by all means come and see us afterwards, because I don't really know what to do with that. But currently we're championing sexual harassment. We're supposed to have champions, but those are the people that your employees feel comfortable to go to and talk to and share their experiences. They're probably part of your reporting procedures. They're probably part of the follow-up, actually, because as with all of these things in employment law, you do your procedures, and then as an employee you go, I think I've done that. And particularly in instances of sexual harassment, the bit that comes afterwards is absolutely key in both protecting the person that has been harassed, whether or not you have found that to be well-founded, and in terms of, well, sometimes protecting the accused, sometimes disciplining the accused. But either way, everybody in that situation is going to need a lot of support, and that is going to be our sexual harassment champion. So we're working on that one. And training, obviously, did you know I do that? There's a whole flyer on it with like quotes and everything. But in all seriousness, the guidance is very clear. You should be training out your staff on how to identify sexual harassment, what it looks like, how to deal with it, whether you are the victim of it, whether you witness it, whether you're seeing it, whether you should intervene and how, and the reporting lines for doing that. So there needs to be specific tailored training on that. What we would say, obviously, is that if you've got to roll out this training more generally, it makes sense to roll it out in relation to all of those other protected characteristics as well. One, because I love delivering that training, but that's not the real reason. Two, the world is changing. What you could say 5 years ago, you cannot say now. And what you can say now, you won't be able to say in 5 years' time. So anyone who's just had training, call me in about 4.5 years. It is changing, and lots of people just don't know what is and isn't okay to say in the workplace. You know, everybody knows that jokes are bound to go on in the workplace. That's what makes it fun. That's what makes it enjoyable. But it's really important that your staff know where the lines are, to be honest, where the lines are crossed, and what happens if they do. It also makes you a modern employer. But more seriously, everybody should know this stuff, because that's where the world's going. Also, it is only a matter of time not to tread on Mr. Chapman's toes, particularly if Labour come in. It is highly likely that the positive duty is going to be extended to pretty much all of your protected characteristics. It's in for one already. It's a fairly easy win to put it in for all of the others. I suspect that will come at some point. Our last reasonable step, of course, is policies. This one really is key. The reason being is this, if you run all the way to the Employment Tribunal, is the only document that is going to be in your hearing bundle in front of the judge. You can't roll me in and say Sarah did training and show them a video of it. It will be, this is our policy, this is our store, this is our stance on equality generally, and sexual harassment in the workplace. Anyone update their equal opportunities policy lately? 1, 2, 3? A few. The rest of you, did you update it in the last year? 2 years? 5 years? 5 years. Probably needs looking at. Because 5 years ago, and we drafted these policies 5 years ago, so sorry, they were very vague, they're very aspirational. It's, oh, we'll be nice, we don't tolerate discrimination, we treat everyone equally, and we'll give everyone the same training on IT. That kind of those general aspirational statements. There was a case that came out last year, and particularly factoring in our new obligations, which says all of that's not really enough anymore. So it's got to focus on current cultures and current terms. And actually there are so many terms in place now that just didn't exist 5 years ago. There are words that we use now that will not be in the policy because they weren't there. They've got to focus on inclusion, focus on society today, and give specific examples of behaviours, which feels really weird in a policy. You wouldn't usually do that, would you? But you've now got to say that this is okay, this is not okay, this is what crosses the line, in relation to particularly sexual harassment, but generally any of those protected characteristics, what terms you should be using, how you should be speaking to people. It needs to set out that reporting procedure, which you thought about, and it needs, bizarrely, to set out expressly who is responsible for that procedure, which, to be honest, is the line we usually take out when we review a policy. It needs to go back in, because there needs to be someone accountable for all of this stuff in your workforce. I would recommend you don't make it you, because it can be a lot more for you. So, there you go. Harriet and I have sold you a lot of policies and a lot of training. So the sales pitch is over. The law is over, because Dan really doesn't know it, if we're honest. He's going to talk about politics.
Thank you, Harriet and Sarah. And my kind friend is going to. Thank you. That's wonderful. So, unless you avoid all reality, you will be aware that there is a general election coming at some point, either this year or latest January of next year. I'm from a bookmaking family, so I take odds very seriously, and as of this morning, this gentleman is 14 to 1 on to be our next Prime Minister. So whilst normally one doesn't like to speculate too much about what's happening in the political world, those odds seem relatively secure to me, and on that basis I'm going to just take you briefly on a little bit of a journey as to what I think will happen. I do have the benefit of having a good friend who works in the government legal department, she's a civil service currently working on the COVID inquiry, and I've been fortunate enough to sort of pick her brains a little as to the sort of inner workings of government, particularly when there's a change of government, what might happen. Because I think it's really helpful to just factor in some of these things in your plans, the topics Harry and Sarah have talked about, also interplay very strongly with what we might be expecting to see coming. So Labour have already put a paper out there saying that within 100 days of being elected they will be passing an employment rights bill. And what that paper says is that they will be seeking to achieve a number of goals. Their first goal is that they want a single worker status for all but the genuinely self-employed. So this is that under current law we have employees, we have self-employed people, and then we have this slightly weird subset in the middle called workers. And workers don't have full rights. Workers have certain rights, but they don't have the full suite of employment rights. Labour want to abolish that category of worker status. So if you are a business that employs workers, temporary workers, those casual workers that are not considered to be employees, you need to be thinking about that, because if it is true that within 100 days of being elected, we don't know when an election is, but let's say an election took place in September, it could well be that by the end of this calendar year, the worker status has disappeared in law. So any clients in the room, businesses in the room that engage a lot of workers, be thinking about that. The second commitment that they have very much ties in with the topic that Harriet talked about in terms of the predictable working pattern. But this takes it a huge step further. Labour have said they wish to ban 0 hours contracts. Now, the predictable worker legislation, how it's touched upon, is a conservative piece of legislation that was born out of the Taylor report, as Harriet told you. And it was actually the Conservative government's response to the pressure that was being put upon them by the Taylor report to ban 0 hours contracts. And their response is, we cannot possibly ban 0 hours contracts. They are vital to many, many industries, many, many sectors. And much derided by some, they're actually lauded by many, and many employees or workers in 0 hours contracts very much enjoy that flexibility. So the predictable working pattern legislation was really a bit of a fudge for them to say, we're hearing the issues, but we're not going to be banning it. Labour say that they will ban 0 hours contracts within 100 days. And this has really interested me from a sort of an academic point of view. How could you actually do that in reality, and would it be a good idea? And that's one thing I've been exploring with my friend. How would that work, and what would they do? And it's clear already within the Labour Party that there's a differing set of views on how it would happen, because Angela Rayner, I'm making no comments about capital gains tax, despite desperately wanting to. Angela Rayner said, when interviewed by Laura Kusenberg, that it would be a complete ban. It is fundamentally an infringement on all employment rights. Rachel Reeves, however, said something slightly different, which was that it might not be a ban, but the legislation will ensure that 0 hours contracts are not abused, and that's a very different thing. So what I've just looked at on that is what have other countries done, because what I've been told is that in reality, when the government wants to bring in some very radical legislation, such as a ban on 0 hours contracts, they tend to just look at other countries and see what they have done. The furlough scheme was a good example of that. That was a piece of emergency legislation stolen from other countries and adapted to fit the circumstances. And so looking at 0 hours contracts, there are 2 countries that have already banned them. One is New Zealand. And in New Zealand, you cannot employ someone unless their contract of employment sets out the minimum amount of guaranteed hours per pay reference period, so week or month. And you must pay those employees for those minimum hours even if they are not worked. However, in New Zealand, you can simply say minimum hours per month, 1 hour. And you must therefore pay the employee for at least 1 hour. So it's a 0 hours contract in all but the minimum number that you set. So that could be one option. In Germany, 0 hours contracts have also been banned, and you must set out in the contract of employment a minimum amount of hours, again, per pay reference period, but the employees are able to flex that minimum by up to 25% either way. So if the contract said we will give you at least 10 hours a week, for example, then actually an employer could only give 7.5 hours, or could expect the employee to work more. That's another way in which it could be done. I do not think that we would see a complete ban. And I suspect the slightly more measured response from Rachel Reeves is where we may end up. But there will be some sort of enshrined legislative predictable position, and it links back to what Harriet was talking about. So I think for those of you that genuinely use 0 hours contracts, casual staff with no guaranteed hours at all, it's important to be thinking about it, because your days are going to be numbered one way or the other in relation to those contracts, and it makes sense to be thinking about it now, because 100 days doesn't give you very much time. So if that were to happen, let's start thinking about it. The other commitment is banning of fire and rehire. This has been in the press a lot over the last few years. It was the P&O ferries was the big example of it, which caused a lot of controversy. And actually most people are not too offended by the concept that you shouldn't be able to fire your entire workforce and then re-employ them the next day in order to get around certain financial or contractual commitments. The problem with it, though, is that what this is actually talking about is that currently, under the Employment Rights Act, one of the fair reasons to dismiss an employee is what's called SOSVA. Anyone brave enough to tell me what SOSVA stands for? Yes, I heard of that. Some other substantial reason. You can terminate an employment contract for misconduct, redundancy, capability, or some other substantial reason. That is what we're talking about here, fire and rehire. It's that kind of catch-all reason to terminate an employment contract. And you often, as an employer, would use that when you're looking to change terms and conditions of employment. You can't get agreement, perhaps with a union or via the employees with consultation. And so you terminate for SOSVA and then you offer to re-employ on new terms. That process is really quite important in certain cases, and that is what is being suggested would become unlawful. It would remove one of the reasons for terminating employment that currently exists. But we'll have to see how that one plays out. More significantly is the fact that the right to claim unfair dismissal is really the cornerstone of employment law. And I know many of you in the room today are probably mostly worried about the employment team here at Leeds Fire and whether we can afford to turn on our electricity in the office in the cold winter days. I can reassure you, you need not worry because it is being suggested that the right to claim unfair dismissal will become a day one right. That's what's in the manifesto paper. Now, again, looking at the detail, I do not think that would happen overnight. At the moment, as I'm sure you're all aware, an employee needs 2 years' service to claim unfair dismissal. And that's a very important tool for many employers to assess the suitability of an employee. It's essentially a 2-year probation period. For those of you as old as me, you'll remember when it was a 1-year period. Some of you may remember other periods. But what is being suggested is that Labour wish it to be a day one right. I would hazard a guess that it will go back to 1 year first, and it might be phased to 6 months. Will it become a day one right? We shall see. The significance of that is absolutely gargantuan. At the moment in this country, almost 50% of employees do not have more than 2 years service. That means across the country, 50% of employees could be dismissed today, and barring all of the exceptions we all know about in terms of discrimination and the like, 50% of people today wouldn't have the right to bring a tribunal claim. That would double the amount of tribunal claims overnight on a simple statistical analysis. The other proposal is that the time limits for bringing employment tribunal claims are heavily criticised in the Labour paper. And one can see that there is a real difference between the speed with which employment claims have to be brought and the speed with which employment lawyers therefore have to act, and all other areas of law. Us employment lawyers look at our colleagues in our commercial litigation department with envy sometimes because they have 6 years to get their claim issued for breach of contract, 3 years to get their personal injury claim issued. Employment lawyers have 3 months. That is being criticised by Labour because they say that a lot of employees in the immediate aftermath of being unfairly dismissed have more important things to worry about than bringing a claim. They're trying to find a job, they're trying to pay their rent. And they want to significantly increase the time limit. 12 months is being suggested as a possible time limit to bring a claim. That will have significant impacts upon employers who know that, for example, in a redundancy scenario, let's get 3 months down the line, we can magically find that this job that we made redundant 3 months ago now exists again. That sort of thing will be more of a risk if the time limits change. The other area of concern for employers, which will completely change their risk assessment of any dismissal is the proposal to remove caps on tribunal compensation. At the moment, if somebody is unfairly dismissed, there is a statutory cap which is just over £100,000 these days, but it's also capped at a year's salary. That therefore gives employers a bit of a worst case scenario. If you unfairly dismiss somebody who earns £25,000 a year, it's a very crude analysis, there are other things to take into account, but very, very crudely, you know it's not going to be a £100,000 claim if you unfairly dismiss somebody. That would change if that cap went, and it is proposed that the cap would be unlimited. And there's a case I'm going to take to you in a moment that illustrates what that could mean. Just in reverse order, the gender pay gap reporting requirements currently apply to those employers who have more than 250 employees. The paper proposes that 250 number won't change, so that's the good news for the small employers in the room. But the bad news is that if you are already having to do gender pay gap reporting, the paper suggests that will also extend to the same type of reporting on the grounds of disability and race, also reporting your pay data in reference to those employers as well, which will be a lot of additional work. The final point is, I don't know if people have heard about this in the press, the bill suggests that the right to switch off will be introduced as a day one employment right. So this is the concept that employees in this modern world that we work in ought to be able, when they're not working, to be left alone by their employers. Everyone who works at the Aspire is probably getting very excited right now about this. The thought of not having me email them randomly on a Sunday when I have a great idea at 8 o'clock in the morning. And what does this mean? So again, I looked at other countries that have already brought this in, and countries that I know that the Labour Party will be looking towards. France already have the right to switch off, but in France this right only applies if the employer has more than 50 employees. And it is open to the employer to negotiate via whether it's a trade union or a staff sort of forum. It's open for the employer to negotiate an alternative deal, but in the absence of that deal, the default position in France for large employers is that you cannot expect an employee outside of their contractual work hours to read an email, to respond to a phone call, to look at a text message. In Ireland, they approach it slightly differently. In Ireland, the employer can still contact their employees outside of their contractual hours, but the employee has the expressive right to ignore it. Deeply infuriating, isn't it? So the employee can look at that email from their boss and think, yeah, I will reply to that at 9 o'clock Monday morning. And that employee cannot be subjected to any detriment for failing to respond to the out-of-hours contact from their employer. This is akin to the slightly often overlooked area of employment law in this country regarding Sunday working. You cannot insist your employees work on a Sunday, apart from certain trades and exceptions. But generally speaking, you cannot ask your employee to work on a Sunday if they don't want to, and if they say they don't want to work on a Sunday, you can't subject them to any detriment for not wanting to work on a Sunday. That might be how this goes in terms of the right to switch off, but that's a cornerstone of the policies that you need to be aware of. Slightly moving away from what Labour may do, there are some other bits of legislation that the Conservative Party have been floating through the system for a while now, which are due to come into force. And we don't know what's going to happen because we don't know whether Labour will endorse this legislation, abolish it, or beef it up. And there are two that I want you to be aware of. The first is in relation to restrictive covenants. This is post-termination obligations, and this is particularly about non-competes. So these are those clauses that are in contracts of employment that say if you leave, you cannot go and work for a competitor for X period of time. The legislation that is sort of slowly meandering through government is currently suggesting that you will not be able to have non-compete covenants that last for more than 3 months. Many of you in the room might have clauses in your contracts at the moment that last for 12 months, 6 months. The legislation is purporting to limit them for 3 months. That might seem a fairly anti-conservative approach. The logic behind it is that it was seen to be entrepreneurial. The Conservative government think that there are people that should leave where they work to set up their own business, but don't because they're too scared about being sued by their current employers. So by giving people this 3-month window, it was thought to be a very entrepreneurial move to assist startups. We don't know what the Labour government's attitude to that legislation is, whether it will happen, whether the 3 months will change. So that's one to keep an eye on. The other thing the Conservatives were doing was the complete opposite to what Labour want to do. I've just told you Labour want to abolish the continuity of service requirement for tribunal claims and that they want to abolish the caps and make it a day one right. The Conservative government are currently passing legislation that says if a claimant wants to bring a tribunal claim, they must pay a fee to the tribunal. Many of you will remember they tried this before, and a number of years ago tribunal fees came into force and a claimant had to pay. The impact was significant. Overnight tribunal claims drastically went down in number, which was the intent. That legislation, though, was dragged through the courts by the trade unions to the point eventually where the Supreme Court ruled that it was unlawful, but the government are having another go at bringing tribunal fees in. My instinct is that Labour will just bin that legislation because it's not in any way keeping with the other things that they are proposing. But we shall see. I mentioned the cap, just very briefly, and then I'll finish. I mentioned the cap on tribunal claims for unfair dismissal could go. Just to illustrate, to leave you in a very depressed and concerned mindset as you leave here today, just to illustrate what that can look like. You might have seen in the press recently that a lady who worked for the council in London, she had only been there less than a year. She was awarded £4.6 million of compensation based on her annual salary of £125,000. The reason for that is that she was able to claim disability discrimination and harassment and therefore didn't need to rely on unfair dismissal. She had suffered from PTSD arising from working and indeed living in the Grenfell Tower. And in her new job, she suffered all manner of pretty grim harassment, it would seem. But what was significant is that in that case, the tribunal were perfectly happy to accept that she was now so ill as a result of losing her job that they accepted the medical evidence that she would never be able to work again, and they gave her career-ending losses. They worked out how much she would earn in the rest of her career, added on interest and so forth, and it got to that very, very big number of 4.6 million. So that's a way of illustrating, if the cap on unfair dismissal were removed, how significant a dubious dismissal could be. I like to end with a bit of sport. I don't particularly like Manchester United, so I thought I'd just tell you that they're getting sued, because that makes me happy. But actually, what's quite interesting here, and a serious note, is that Manchester United had a data breach where they accidentally sent payroll information for 167 employees to an outside third-party company. They were reported to the ICO, and the ICO, as they occasionally do, came back and said, I think they had a cyber hack. They said, we understand, it was a mistake, these things happen, slap on the wrist. ICO didn't tell Manchester United off. The employees managed to find a lawyer, clubbed together, and each employee is suing Manchester United for compensation for their data being breached, and they're claiming £3,000 a head. So if ever there's a reason, again, to just be mindful of your own data breaches and the consequences, there is that. We are at 9:30, so I promised we would let people go that needed to go. We're going to be downstairs. Come and talk to us if you have questions. The feedback forms are in the packs. If you want to complete those and want us to send you any information, do that. Otherwise, come and talk to us if you want to. If you have actual work to go and do, we wish you well. Thank you for coming. I hope you found something useful, and great to see you all.